let's break this down because we have some big changes and some minor changes that are still going to have a big impact in our daily practice.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
Next month, amendments to Rule 3002.1 will become effective, which will alter how mortgage payment activity is verified and reported in Chapter 13 proceedings. Joining me today to walk through these changes is Friedman Vartolo associate Lauren Moyer. Lauren, thanks for joining me today.
Happy to be here.
Before we get into what's going on, so Rule 3002.1 has been amended. The amendments are taking effect in December, is that correct?
Yeah. So we are going to see these go into effect December 1st. So everyone get ready.
So how long ago did this happen?
So there's been buzz about this for maybe a year and a half. I would say the committee puts out comments and proposed amendments, and then they open it up for comments. So we are at the final stage. We are at the implementation stage.
So these amendments, what actually is going to change?
There's a lot going into effect on 12/1. So let's break this down because we have some big changes and some minor changes that are still going to have a big impact in our daily practice. This is not an exhaustive list. So if anyone has any questions following this video for more in-depth analysis, feel free to reach out to me because there's a lot, again, going into effect. We can only cover so much in this segment. So the first thing, all of these changes have new federal forms. So those are going to be on the court's website. They are required forms to be used, and each of these changes has its own form. So now getting into the impacts itself, one of the bigger changes is the applicability of Rule 3002.1. This is now going to be, it's still for a security interest in the debtor's personal residence, but now it's opening up the amount of loans that applies to within that subclass. Now it is going to be for any loan for which the plan provides for the trustee or debtor to make a payment on the debt. So that is going to bring more loans under the umbrella of 3002.1 filing. For example, like cure and maintain plans, which are common that we see for the debtor to cure arrears and the trustee making those payments and then the debtor making post-petition payments, right? Now it's also including, for example, loans that have a cram down into effect. So say there's not a ton of equity in the property. Those are common in bankruptcies. We did not used to have to file 3002.1 notices on those cases. Now we will. Also, reverse mortgages are now going to have these and total debt loans. So all of those loans that we didn't have to file 3002.1 notices before. So total debts, reverse mortgages, cram downs, we're going to have to file on those once this goes into effect.
Okay. So both the actual forms are changing and the types of situations where we need the form is also expanding. What's the goal? Is it just to provide more information in those situations, or why do you think the scope's being expanded?
The stated goal is to provide more clarity to both debtors and trustees for these filings. We'll see in practically speaking what that shakes out being.
What's actually being included in these forms?
So the first form that's going to be affected is the notice of mortgage payment change. They're adding a HELOC section to that. The home equity line of credit, they typically change a little bit each month, and it's cost prohibitive to file. So a lot of creditors just choose not to file and to eat the cost. This new 3002.1 form is adding an annual reconciliation for HELOC loans specifically, where if the amount changes by $10 or less annually, the lender can just file one notice of mortgage payment change at the end of the year and include that reconciliation. So that's going to be a big benefit to creditors with HELOC loans.
Practically speaking, forms are changing. Things are going to be different. But if I'm a servicer, I'm thinking to myself, okay, great. I have Lauren. She handles all my forms for me. She's going to take care of it. Great, Lauren. You have more work to do. How does this actually impact the servicer? Like, I gather there's going to be communication where they really need to be aware of this stuff, right? And we could be asking for additional information that we weren't asking for before. So how do you think it would actually impact a servicer who handles bankruptcy work with our firm or a different firm?
So we as a firm are obviously on top of all of the form changes. So the servicers don't have to worry about any of that. Some of these new filings have additional documents that have to be filed with them. So, for example, with the update to the notice of final cure, it's now going to be called a notice of disbursements made that's filed by the trustee towards the end of the case. We now have to file a payoff with our response. That was not an obligation before. So, in addition to whatever other documents that were required under this before, so for example, post-petition payment history, if we disagree with the trustee, the servicer is now going to have the burden of running payoff for all of these responses that we need to file.
I gather this is universal across all districts. Is there any variation across districts, or this is just federal across the board?
The forms themselves are federal, but like any area of bankruptcy, each jurisdiction is going to put its own twist onto it, and we'll see that as these begin being implemented.
I know you mentioned everything's taking effect on 12/1. Is there any trailing thing to that, or we're really saying 12/1, in this regard, everything changes and we go forward, or is there something that comes after that?
Everything goes into effect 12/1 for new and existing cases.
One other thing I wanted to touch upon, I know there's a new form for a motion to determine mortgage status. Can you just walk us through what that is and how that'll impact things?
This is the biggest change with this round of 3002-1 updates. So this can be filed by either the debtor or trustee at any time during the bankruptcy. So that's a huge change from how we see these forms being implemented in the past. And it's going to include from the filing party what they believe has been paid. The creditor then has 28 days to respond, and the creditor has to respond if they dispute the figures that are in this motion. And again, these motions can be filed by either the debtor or the trustee. So that is going to be a big burden for servicers to bear. Again, these responses, they have to include a payoff statement, and they're going to include a plethora of information like any post-petition payments that are outstanding, a breakdown of fees and costs. So we have to be careful of these coming in. It is a hard filing deadline. If we, the servicer, are disagreeing with the trustee or the debtor's figures, which particularly with debtors, I anticipate is going to be common, we have to ensure that this response is filed to preserve our rights and also attend the hearing that the court is going to set, where the court is actually going to determine the payment status. So this is a huge change brought about by this amendment.
All right, Lauren, I really appreciate it. This was very informative. I mean, this is clearly a big change. I think anybody that's working for a servicer or for a bank or for a lender in the bankruptcy department really needs to be aware of this stuff. Because even if it's not changing your day-to-day workflow, the communication is going to be different. There's going to be different terminology, and you really have to be aware that these new forms are required. Thank you for joining Lauren, Moyer, and I on The Weekly Friedman, your source to the most essential information in the default industry. Thanks for tuning in, and looking forward to seeing you next time.